Hello everyone, welcome to the Charles Taylor Adjusting webinar on bunker quality and engine damage claims. My name is Rui Howe and I'm an Associate Director of Lindley, Liverpool office at Charles Taylor Adjusting. I'd first like to cover some housekeeping items before introducing our speakers today. Please know that this session is being recorded and we will send all attendees a follow-up email with a copy of the recording. At the end of the webinar, you will see a short survey. This should only take a couple of minutes to complete, and we'd be very grateful for your feedback and suggestions for future events. Just so that you're aware, all attendees are muted. However, if you do have any questions throughout, please type them into the questions box on your side panel throughout the session, and we'll answer them at the end. It gives me great pleasure to introduce our speakers today. Our first speaker is Diego, and he will be talking about the technical aspects of bunker quality claims. Diego is the Managing Director and Consultant Chemist for CMC Marine in Singapore, now part of Charles Taylor Marine Technical Services team, following Charles Taylor's recent acquisition of Cosulich Marine Consultants Group. After graduating from the University of Genoa with a bachelor's degree in chemical engineering, Diego spent a short space of time at an insurance broking firm and a law firm. In 2007, he joined Lab Cosulich as marine cargo surveyor. Since 2010, he has been based in Singapore. He has vast experience in dealing with all kinds of cargo quality disputes involving petroleum products, chemicals, vegetable oils, coal, ores, and other dry cargoes. Following up, Andrew will share his expert opinion on the technical aspects of engine damages that result from poor quality bunkers. Andrew joined Charles Taylor in February 2019, following a career at sea. He has experience of different vessel types, such as container ships, tankers, supply ships, anchor handling, and subsea support vessels. Andrew is a member of the Institute of Engineering and Technology, and a member of the Institute of Marine Engineering, Science and Technology. Last but not least, Amy will share average adjuster's view on claims for contaminated bunkers and engine damages that result from contaminated bunkers on hull and machinery insurance policies. Amy joined Lindley in 2006 after graduating from the University of Liverpool with a first-class bachelor's degree in psychology. She qualified as a fellow of the Association of Average Adjusters in 2013. Amy has spent time working as an associate director in Lindley Singapore office and is currently the managing director responsible for overseeing Lindley Liverpool office. She has experience of handling a variety of hull and machinery claims, as well as large container ship general average cases and general average salvage security collections. At the end of the session, we will have some time for the Q&As. I will now pass over to our first speaker, Diego.
Thank you, Roy. Today, I shall speak about a case I handled concerning a bunker quality dispute. In particular, a bunker with a high level of TSP, or total sediment potential. This particular case was chosen as TSP is one of the most common off spec since the implementation of IMO 2020. Most people thought sulfur would have been the issue, whereas TSP seems to be the parameter which is creating the most problems. Our role in this dispute has been as a consulting chemist and surveyor, providing guidance to the ship owners P&I Club and to the ship owners on all technical aspects of the claim. Now, the case concerned a parcel of 1,000 metric tons of bunker fuel oil delivered according to the specification ISO 8217-2010. As per usual procedure and according to their own bunker testing program, the vessel sent one of the samples taken at the ship manifold during bunkering to the laboratory for testing. This before starting to use the fuel, of course. So the analysis was completed 2 days after, and the results showed that the fuel was off specification for TSP with a result of 0.12 against a maximum limit of 0.10%. You can see on the right side of the slide the actual certificate of analysis issued by the laboratory. Now, the first step of any investigation is to understand the type of specification. You want to know what this off specification means for your vessel in terms of handling and or using the fuel. According to the type and also to the entity of the off specification, you have very different options. For example, if the off specification parameter is just the viscosity, it usually is not that serious and may be easily dealt with on board by the crew. So you don't have to disembark the fuel just because it is off spec for viscosity, for example. If instead we're talking about cat fines, TSP, or other parameters, then it may be a serious matter, and it is well possible that your vessel just can't use the fuel oil at all. So going back to TSP, what is TSP? TSP stands for total sediment potential, and it is a measurement of the stability of the fuel. Fuel oils are blends of various types of hydrocarbons, which have very different characteristics. It is important that these many components remain in a blend, meaning in a solution. If the fuel oil is unstable, meaning a high level of TSP, it means that the heavier components will start to drop out of the solution. And this is a major problem, as it can provoke filter blocking, which means that your engine stops receiving the fuel, or purifiers overflowing, and or various actual engine damages. Now, I mentioned the ISO 8217-2010, which I believe you are all familiar to a certain degree. The ISO 8217 is a standard quality specification for fuel oils, and almost all supplies worldwide are done according to it. This specification lists several tests which shall be performed on the fuel, such as, for example, density, viscosity, aluminum and silicon, just to mention the well-known ones. There have been various revisions through the years, with versions issued in 1996, 2005, 2010, 2012, and 2017. And it is important to understand that these different versions have different testing parameters and some different limits. So you really need to know what your contractual specification for the bunker delivery is, and this is important because a fuel may be in spec according to one version of the ISO 8217, but off spec according to the other version. So now we pass to what we did on board the vessel. This step can be called the collection of evidence. Now, why would we need to attend on board? The reason is simple. Before proceeding with a claim and all the issues related to it, you want to confirm that the fuel is actually and truly off specification. This because the laboratory, which found the TSP of 0.12%, may have made a testing mistake, or also it may have tested a sample which was not correctly taken by the crew during bunkering. So what we did was taking samples from the bunker storage tanks, which contain this fuel. The samples were immediately sent for testing at the local laboratory, and the fuel was confirmed to be off specification, with the results ranging from 0.13% to 0.18%. You may note that the level of TSP had increased from the 0.12 initially advised by the laboratory to up to 0.18%. Which means that the fuel became even less stable. This is to be expected, as an unstable fuel will become more and more unstable with time. So its TSP will naturally increase with time, making it more and more difficult for the crew to handle this fuel on board. On top of the sampling operation, while on board, we verified that the fuel oil was still stored in the original bunker tanks and that it had not been used or mixed by the vessel. This is another important point. In addition, we collected the relevant documents and verified which samples from the supply were available on board. These samples were disembarked by us and sent to our office in Singapore for arranging a joint testing. We pass now to what we did in the office. So the documental review is as important as attending on board. What you need to clarify is what is the contractual specification and which sample shall be tested in case of a quality dispute. You don't want to base a claim on the results of a sample which is not contractually relevant. By reviewing the charter party and the BDN, we found out that the quality was based on the specification ISO 8217-2010, which has a limit for TSP equal to 0.10% maximum, and that the dispute should have been settled on the basis of one of the samples taken at the ship's manifold during bunkering and listed on the BDN. So in order to proceed with the claim, we drafted a testing protocol in which we listed which samples would have been tested, at which laboratory, in which date, and according to which testing method. This was circulated to the parties in order to invite them to attend by sending their own experts and surveyors. There is always, as you can imagine, some issue between the parties as to which samples shall be tested and for which methods. The claiming party usually wants to add as many samples and as many test parameters as possible, whereas the other parties tries to keep it to a minimum so that there will be less evidence in the claim. In this case, we ultimately managed to test the contractual samples and also the samples taken from the bunker tanks. We wanted and insisted to test also the bunker tanks samples to show that the fuel on board had an even higher TSP due to all the delays and that it could not have been used under any circumstance. Now, this is what we did in the laboratory. When we attended the laboratory with the representative of the charterers and the suppliers, we identified the samples and verified their conditions. Among the various samples, the one provided by the supplier was found to be allegedly tampered with. In particular, a hole was found between the bottleneck and the cap. This, as you can see the picture on the right side, this suggested that the cap had been pried off and the fuel inside changed with another fuel which we expect would have been in spec. On this basis, we rejected the sample, which could have been highly detrimental to the ship owner's claim. After that, we verified that the laboratory instruments were properly calibrated. These steps include a documental verification as well as running a trial test on a known result sample. And once the analysis had been completed, the results obtained confirmed that the fuel oil was of specification, with the ship manifold sample giving a result of DSP of 0.13%, and the bunker tanks samples giving a result of up to 0.18%. You can see on the right part of the slide the results of the manifold sample. Nevertheless, it's never so easy. Since it was off specification by what the charter has described as slightly, the charter has insisted that the fuel oil was still acceptable, as 0.13% was within the ISO 4259 allowance. This is very important, and I believe many of you experienced this issue, since the ISO 4259 is a major topic, and it is often used by the suppliers as an excuse to have their off-spec fuels accepted. The ISO 4259 is a method included within the ISO 8217 specification. So it basically is enforced on almost all supplies worldwide. This method describes what to do in cases of slightly off-specification analysis results. Basically, although it is extremely technical with tens of pages of formulas, it says that since all laboratories will make small and natural mistakes during testing, all results have a certain degree of error or uncertainty. This is used to by the suppliers to say, look, my fuel tested just slightly off spec, so you cannot be sure that it is actually off spec, and therefore you have to accept it. This is of course incorrect, as the ISO 4259 does not provide a range of acceptability, but only does provide a range of acceptability, but only when you have a single analysis result. So basically it says that one result, if it is just slightly off spec, is not sufficient, and you have to reconfirm it. And this can be done in many ways. For example, by testing the fuel at another laboratory. Therefore, once confirmed, a result of 0.13% of DSP is off specification, even if it is slightly off specification. So after various back and forth messages with the charterers and the suppliers, explaining them what the ISO 4259 actually meant, the charterers disembarked the parcel of fuel oil. So, what are the conclusions from this case? Well, first, for sure, and this is something that I stress to all my clients, keep in mind that your claim is just as good as the samples taken. If the crew or some surveyors attending on board take samples which are not representative, then the results obtained by the laboratory will be wrong for sure. Second, make sure you know what your specification is and which sample is the contractual one. You want to avoid going through a joint testing operation, which may be expensive, only to have your results being not enforceable because the sample tested is not the contractual one. And the third, have an expert to guide you through the claim. This includes attending on board, reviewing the documents, and attend the seal breaking and testing operations. You want to avoid the crews taking unrepresentative samples, laboratories reporting wrong results, or even testing tampered samples, providing results which are detrimental to your case. So thank you, it was a pleasure, and I now hand it over to Andrew, which will explain to you what happens to your ship when you do use an off-spec fuel.
Thank you, Diego. Good morning. My name is Andrew Kingshott, and I'm part of Charles Taylor Adjusting, a team of engineers who supply technical advice to adjusters when presenting a claim. And today I'm going to go through the technical aspects of the damages that are a result of poor quality bunkers. We're going to split this into three main sections. We're going to have a look at the fuel storage on board, what the crews can do in order to handle the fuel, in order for it to be used within the engine, and also the types of damages we see when claims are presented where we have contamination of the fuel. When we're talking about storage, we look at the fact that bunkers should be always loaded into tanks that are empty. We also have a look at the stability of the fuel. So the correct management on board is quite essential. We'll also be having a look at the handling of diesel fuel. It's becoming more common, however, it's not without risk of contamination. An additional point that is being noted now since IMO 2020 is the temperatures in which we handle these fuels. So fuel storage on board. Where we have IMO 2020, obviously vessels are now taking on different blends of fuel, where it's a shift from the HFO and MGO. We're now having very low sulfur fuel oils and ultra low sulfur fuel oils. So once the fuel has been bunkered, it's up to the crew to ensure that the fuel is handled correctly. However, you have to also make sure as crew that the fuel that has been bunkered will not cause problems with stability should it be consumed. After bunkering, you're supplied with a bunker delivery note. However, owners should always do a third-party analysis on the bunkers, as the bunker delivery note does not always supply all the information of the components of the fuel. And it's not unheard of to have fuel that may be off spec, however the bunker delivery note says otherwise. Another method the crew can use is the spot test, and that is when we mix the two fuels that we're about to start using together. We add it to a test paper and then we heat that test paper. Depending on the result, you hope to see one clear circle. Here we can see on the slide on the right hand side at the top, you will see there is a circle within a circle. That is an indication that you will have sludge formation should you mix these two fuels together. So this is something that the crew can do on board. Additionally, temperature control should be focused on. This is not only the storage of distillates, which should always be 10 degrees above their pour point, both in storage and the settling tanks. However, with your residual fuels, we're looking at temperatures of 10 degrees again above their pour point for the storage, about 65 degrees at the settling tank. We also look at tank cleanliness. Obviously, the tanks are clean during the dry docking periods. However, contamination such as catalytic fines can collect in the bottom of tanks, and this should be explored when you're doing your tank inspections on an annual basis. as part of the inspection, it's good to clear the tank as well. And then we move on to diesel fuel oil contamination, and it's commonly termed diesel bug. I think that it's the most common phrase used. And again, the crew can check for this using dip slides, which are a quick and easy test to see whether or not you have any bacterial growth within the tank. And that is due to water forming within the tank and then feeding the bacteria that may be within the tank. It's becoming more apparent as blends become, you receive biofuel in the tanks within the fuels. And the problem with the diesel bug particularly is the fact that as soon as it takes hold, it's very hard to get rid of. The only way you can effectively get rid of it is to heat and use chemicals just to remove the bacteria. We move on to the next section of the fuel handling system, which will be your oil filters and separators. Now, we've seen in the past sediment and phenols blocking fuel filters, and that's a picture on the right-hand side of an auto filter there, experiencing exactly that. Main engines, large two-strokes, should have an automatic self-cleaning fuel filter before the fuel inlets into the engine. Now, this will remove particulates up to 10 micrometers in size. However, if you have a large amount of sludge and phenols within your fuel, it will overwhelm these filters, and they should alarm, informing the crew of that contamination within the fuel. Phenols, on the other hand, you will not know about, because they're not generally tested for, even as part of third-party fuel oil analysis. And phenols are a particularly sticky substance and can cause varnishing of components such as fuel pumps and injectors. Fouling of fuel oil separators is also becoming more common with the use of low sulfur fuel oils and ultra low sulfur fuel oils. And one aspect that's been raised quite a bit is the temperatures in which the fuel is heated to achieve the separation, to remove not only particulates but water within that fuel. And last but not least, pump damages. Transfer pump damages is from the storage tank or bunker tanks into your settling and service tanks. This can happen, but it is down to the temperature at which you heat those fuels in order to pump them into the settling and service tanks. When we look at the fuel pump and injector damages themselves, what we tend to see is, in the event of catalytic fines, for example, you'll find there is wear to the plunger within the fuel pump, and that's down to abrasive wear. It is very important that the fuel is clean as it goes into these engines, because the tolerances that these components are machined to are very fine. So it only takes a very small amount of contamination for these to damage. But not only that, it's not only mechanical abrasion that can cause damages to these fuel pumps. We also look at corrosive and chemical damages to fuel pumps. When we do have contamination of the fuel, particularly in the case of catalytic fines, we tend to see the progression time of the damages to be quite short. And not only that, the damages are spread across the whole of the engine. It's not normally localized to just one pump or one unit. And as the engines have evolved from your MC to ME or your electronic engines, you will also find damages to the injection control units, which aren't normally overhauled by the vessel crew. So this can incur additional costs to the owner. When we assess damages, as far as fuel contamination goes, from an engineering perspective, it's important that we have information as to the overhaul durations, periods between when the pump was last overhauled and when the damage occurred. And this is to assist in deducing whether or not this is just general wear and tear, as you will get an element of wear and tear with these parts, or whether or not it is sudden, and whether or not these tolerances were, the wear was out of tolerance before the contamination occurred. Is a photo of exactly that catalytic fines here on the helical jerk type pump. So this on the left hand side is the plunger, and denoted by the arrow is our abrasive wear to the side of the plunger. On the right hand side, when we look at it at the microscopic level, we can see the catalytic fines on the lower part of the plunger. Now, it is normal for fuel to pass around the side of the plunger, between the plunger and the barrel, for lubrication. However, if you have a high concentration of catalytic fines, it will also draw down those fines into that space and wear away the plunger. As discussed previously, we also have corrosion. Now, ISO 8217 goes through your basic requirements of fuel. It does not go through the requirement to test for chemicals or chemical contamination. And that's prevalent in cases where we have high concentration of phenols, for example. However, there is a clause that fuel should be free of any material that renders it unacceptable for use in marine applications. And it's something that Mozilla, particularly in their technical advice RT126 data and specifications notice, where they say that chemical waste in the fuel can lead to damage in the fuel injection components, rendering them inoperable. So they do suggest testing the fuel for chemical contamination. However, this is not a common test done. Normally, when you do a third-party test, you do get the full results of what you might not have in the bunker delivery notice. However, it might not necessarily outline the presence of phenols. Additionally, sulfur, the sulfur concentration within the fuels has an element of lubricity. With IMO 2020, we've now reduced the sulfur content within that fuel, and therefore you reduce lubricity. And this has been highlighted again by Wärtsilä in the fact that their ICUs, the injection control units on their electronic engines, are designed for residual fuels. And subsequently, they have advised that the time between overhauls has been reduced by 25% if you were to start using very low sulfur fuels. And that's noted in their business white paper in relation to running two-stroke engines on low sulfur fuels in way of IMO 2020. Another part of the system which is affected by contamination, not only are the injection equipment such as the pumps and the fuel valves, but we also have a look at the fines that are embedded within the surface of the cylinder liner, and this is where we get a lot of abrasive wear between the piston and the liner. And what tends to happen is the catalytic fines, should you have a high concentration of them, will embed themselves into the open structure of the surface of the cylinder liner, and therefore it reduces the efficiency of the lubrication of the cylinder liner. Then you get abrasive wear and in some cases adhesion. MAN suggests that a concentration of 200 fines per square centimetre is considered healthy and normal. However, when we have damages, we will take a sample of the liner and we'll be able to see the actual concentration that is present on the liner. Here we have this photograph of the exact same liner in our previous slide. However, the left-hand side is, as you can see from sight, and when we magnify it, you can see the catalytic fines that are embedded within the liner. Another element of the engine which is affected by fuel contamination is your piston and your piston ring damages. So as the piston is travelling up and down the liner, it will have abrasive wear, and that will damage your piston rings and the piston. In extreme cases, you may have wear to the stuffing box and piston rod. We have seen in some cases it's not very often, but in some that the system oil has also been contaminated due to the stuffing box having experienced severe wear. If the cause is not identified, if it only affects one unit, it will affect generally all the units, but if you only discover one unit at a time, unless you identify the fact that you've got a high concentration of catalytic fines, abrasive wear will continue to the other units. Even after overhaul, it's not uncommon for us to see the same unit overhauled twice because the identification of catalytic fines, for example, has not been identified. And a lot of this can be managed on board. Should the fuel be, it may be poor, but within spec, you can still condition it using centrifugal purifiers on board. And the golden rule is to try and ensure that the flow rate through that purifier is the same or slightly over your consumption. We do see sometimes that the fuel is being passed through the separator too quickly, so it doesn't have enough time to separate those contaminants out of the fuel. And as a result, you will pass over catalytic fines into the fuel, into your engine, should it pass the filters. And another aspect of that is you also create a lot more sludge for the efficiency of the purifier. So it's an additional cost to owners that shouldn't really occur. And they are our damages that we see as far as contamination of poor fuel within the engines. I'm now going to pass over to Amy, who is going to have a look at the average adjuster's perspective on bunker contamination and engine damage.
Thanks, Andrew. Okay, I hope you can all see that. Right, so I'm going to talk now from the adjuster's perspective about some of the issues that can arise when adjusting claims for damages that result from the use of off-spec or contaminated bunkers on board the vessel. So claims for damages arise from the use of contaminated bunkers, and from time to time, and adjusters see those. But there are also occasions where there are a spate of these type of claims. For example, you might recall claims arising from the use of off-spec bunkers which were supplied in the ports on the US Gulf Coast in 2018. And they gave rise to a significant number of claims for damages to vessels, varying in severity. And we've also seen similar instances with bunkers supplied in Panama and also in Singapore. And the reason that this particular contamination is an issue for ship owners and their insurers is that it's not customarily picked up on the standard testing, so the contamination goes undetected. So if we consider a case example to illustrate some of the issues, on this particular case, our vessel is trading across the US, Europe and the Middle East, and on the 29th of April, the vessel loads bunkers into 2 empty tanks in Houston, USA. It departs the next day for various ports in the US and Europe. I should point out that the bunkers were taken on in accordance with the vessel's procedures for safe bunkering. And the relevant samples were taken and sent for analysis, and the results came back saying that the fuel was in specification, although there was a recommendation that crew carry out standard onboard treatment to reduce the catalytic fines in the fuel oil because they were on the higher than average side for that grade fuel, but they were within specification. So later on during the voyage in May, following the purification of the bunkers on board, the fuel began to be used by the vessel, although en route from Europe to Egypt. A couple of days later, the main engine shut down during the voyage. The crew investigated and they found various damages to the fuel oil system. They changed the type of fuel they were using and they flushed the lines. They replaced what spares they had on board, and they managed to arrive in Alexandria a few days later, where they undertook repairs. And while they were there, they also discharged the off-spec bunkers and cleaned the tanks. And when they finished, they completed repairs and they continued on their voyage. So, Ship owners contacted the average adjuster and asked them to deal with the claim arising on the policy. As adjusters, when we're faced with this kind of casualty, one of the first things we'll be thinking about is the cause of damage and establishing the cause of damage so we can ascertain whether there is positive cover under the H&M policy. And then once a valid claim is established, we'll be looking at the particular costs incurred and to what extent they're going to be recoverable under the H&M policy. So regarding the cause of damage, this is where the surveyors, for example, the H&M surveyor or consulting surveyors and the technical experts, their input is really vital to explain all of the details and look into further testing of the bunkers, the more in-depth analysis of what's going on there, as Diego spoken about and Andrew, and also look in more detail at the physical damages to the vessel to try and just identify the approximate direct cause of the loss. So in practical terms, once all of the information is received in the survey reports, we'll review those and pass them to owners, and we'll ask owners for their allegation of cause of damage for H&M surveyor's agreement. So in this case, the owners alleged that they believe the damage was a result of the bunkers being contaminated with substances not picked up during standard testing, and therefore the damages would have occurred in any event, regardless of crew efforts in purifying and filtering the bunkers prior to use. And you'll see the H&M surveyor also agreed with that. The fatty acids and other contaminants found in the fuel led to a corrosive attack and subsequent abrasive wear of the fuel oil system and main engine, resulting in the damages observed. So they've agreed the cause of damage. It was the off-spec bunkers. So then we would look at the policy conditions, and in this case we've got the Institute time clauses hulls. And this insurance covers loss or damage to the subject matter insured caused by, and lists the various insured perils: accidents in loading, discharging or shifting cargo or fuel, bursting of boilers, breakage of shafts or any latent defect in machinery or hull. The one we usually look at in this type of cases is negligence of master, officer, crews or pilots. And it also covers negligence of repairers or charterers. And in our particular coverage, we've also got the Institute additional perils clause, which is extended to cover loss of or damage to the vessel caused by any accident or by negligence, incompetence or error of judgment of any person whatsoever. And both clauses are subject to the due diligence proviso, which we can come on to in a little later on. So we're going to pause here for some polling questions for the audience. So given the cause of damage, which we've heard already, do you think there would be coverage under ITC Hulls 11083 alone within the policy? Okay, I think that is most people, or 60%ish think yes, 25% possibly. And what about if the policy had the additional perils coverage that we just spoke about? Yeah, everybody's quite happy if there's additional perils that there will be coverage. Okay, great, thank you. Okay, so when we're looking at this type of damage for fuel resulting from fuel issues, there are generally two potential categories of causes, and this is generally either the first is that off-spec bunkers were simply loaded and the owners were unaware of this, and the second is when there's an intervening act of negligence that results in the bunkers being unfit for use. So, for example, crew negligence in the purification process or the standard treatment of the or mixed of bunkers on board. They did something incorrect in that procedure, and it resulted in the bunkers which were suitable for use becoming unfit for use. In our case, the bunkers were found to include contaminants, and they were off-spec from the start. So from a coverage point of view, if we look at the insured perils under ITC Hull 6.2, it's hard to find an insured peril which covers this cause of damage. There was no intervening act of negligence from crew. It was just that the bunkers were loaded and they were off spec, and it was unknown to owners because it wasn't picked up on the standard testing. So under ITC hulls, there is no positive cover. And with regard to the wider coverage of the Institute Additional Perils clause, then yes, the damage, that clause offers wider cover, and the damage was clearly fortuitous in nature. It was accidental, it was not the result of ordinary wear and tear. So there would be a basis for a claim under that clause. As I mentioned, both clauses have the due diligence proviso. And this is generally applicable to higher level management, and this will be above the superintendent. And so generally, provided that the correct procedures for bunkering and treatment on board were in place and the necessary equipment was provided to crew, it's generally considered that there wouldn't be a lack of due diligence on the part of the assured unless there is some evidence to the contrary. So if we move on to the recoverable costs and the type of costs that might be incurred by owners in respect of such a case. So we've established that there's policy liability for the main engine damages, and the next step is going to be to consider the costs. The subject matter insured under the H&M policy in this case is hull, machinery, equipment, everything connected therewith, nothing excluded. And under English law, it's established that if the fuel is owned by the assured, then it forms part of the ship, and that's under the Marine Insurance Act, Rule of Construction 15. So owners claim they've obviously got the main engine damage repairs. The policy covers the reasonable cost of repairs to the physical damage to the ship. And so what we would do is request the H&M surveyor's approval of the repair related costs as fair and reasonable and casualty related. And then as adjusters, we would adjust the remaining allowance in accordance to usual practice and adjusting practice and rules of practice. So we'd have costs such as obviously the spare parts of shipyard accounts, technicians, port charges. There may be removal allowances to consider. There could be temporary repairs, overtime, things like that. So that's the actual damages to the vessel itself. But this is our third polling question coming up. What about the cost of replacing the contaminated bunkers themselves? Do you think this is a cost that's going to be recoverable under the policy in this case? Okay, we've got about 60% no, 30% yes, and then 11% possibly. Okay, well, in this case, because the fuel was not contaminated, but the oil was not contaminated by an insured peril, then the cost of replacing the oil itself is not going to be allowed as part of the claim. Oh, sorry, I should have moved on to the next slide. Yeah, the loss of the bunkers itself is not going to be recoverable. It wasn't contaminated as a result of an insured peril. They were loaded in an off-spec condition already, and so there's no claim on the policy for that loss. The same goes for the discharge of these off-spec bunkers and reloading new fuel. That wouldn't be recoverable either, because the fuel itself isn't allowed, and you have to look at the approximate, the predominant reason that the fuel was offloaded. And so there is often an argument that, well, the cost of discharge should be treated as part of the cost of cleaning the tanks, and it had to come off to clean the tanks, so it should be part of the damage repairs. But that's not really the primary purpose for the discharge of the fuel in this kind of case. The primary reason is because it's unusable, it needs to be removed from the tank so it can be sold or disposed of. So it doesn't form part of the reasonable cost of repairs, and it's similar to discharging worthless cargo at destination to enable repairs. And it was established in Field v. Burr back in the 19th century that discharging of the worthless cargo wasn't going to be recoverable from H&M as part of the damage repairs. The cost of cleaning the contaminated fuel oil tank itself, once the fuel is out, is reasonably allowed as part of the cost of damage repairs to the vessel as a direct consequence of those contaminated bunkers being on board. So that is an overview really of some of the main issues surrounding policy liability and also recoverable costs in cases where we deal with contaminated bunkers. There are some other considerations which come up on these kind of cases. So if there was cargo on board the vessel and they suffered a main engine breakdown at sea, you might have a GA type situation to consider, and there may be allowances if ship and cargo were in a position of peril at that time in general average. And likewise, if ship was on its own and was in peril, then you may have a salvage claim or sue and labour claim for those costs in addition to the cost of repairs. If you've got a loss of hire policy, there may be an associated claim there. Recovery action on particularly where off-spec bunkers are provided and from the outset, it's quite a difficult topic and it's a very complicated matter because there are often issues of who's actually responsible. There are complicated contractual chains between the parties, and also the bunker suppliers' contract terms are often very restricted and they offer a very short period under which allegations can be made. In these type of cases, the bunkers aren't used straight away. Generally, they're taken on board the vessel and then they're treated and they're used when the other bunkers are running low. And so it may be some time between the two, and by that point, the limitation may have passed. Likewise, the contracts may have limitations on amounts and types of damages that could be claimed. And it's of course costly to attempt to make a recovery. There's all of the expert reports, legal fees, complex disputes. So it's important that the P&I Club and also the H&M insurers who will be subrogated if they've paid any costs which are recovered are all brought into this early on. Of course, what can owners do about it? Well, they can undertake enhanced bunker testing before use, but there's a cost to this and a time element. So the preventative measures are also quite tricky for owners to deal with. But that's me. That's our overview from the adjuster's perspective. I think I should hand back to Rui for questions. Thank you very much.
All right, thank you, Amy, Andrew, and Diego. We've got a few questions from the audience. The first one, have we seen an increase of engine damage claims after 2020 low sulfur switch? Well, I think this is a good question for Andrew.
Thank you, Ray. That's a good question. There was a lot of speculation as to what would happen after the switch in 2020, and a lot of it was based around use of scrubbers and such. However, there's been a few claims we've seen, not many, relating to the switch to low sulfur fuels, and we've put most of them down to the fact that it's the management of the cylinder oil on board more so than actual handling of the fuel. Obviously, a different sulfur content will need a different cylinder oil to neutralize the sulfur within the fuel. And as we go into lower sulfurs, obviously the TBN of the base number of the cylinder oil also has to change. However, a recent BIMCO International Chamber of Shipping Intercargo and Intertanko survey was sent out to vessels, technical managers and owners relating to the switch over to low sulfur fuels. And roughly 50 to 53% of respondents reported an increase in sludge deposits in either their fuel tanks, the clogging of fuel pipes or separators. And a lot of the comments that came from the 53% stated that it was more the variance in the viscosity of these fuels. So the temperature when you're separating is vital really to get efficient separation. So where we're seeing fuels of different characteristics, it's proving a bit of a problem when it comes to sludge deposits. Additionally, we've also seen about 30% reported increase in wear of cylinder liner, piston rings and other components due to an increase in catalytic fines. Now, where they're producing these low sulfur fuels, it's either by dilution or chemically. Where they're blending the fuels, you may see an increase in catalytic fines, and it was also observed last time when we reduced the sulfur within the fuel. So we are seeing a slight increase, but there's nothing. It will take a long time really to see whether or not it has any real adverse effect. But there are indications that it's more to do with the sludge production than wear and tear.
Thank you. Thank you, Andrew. Right. Second question. Is the industry working towards harmonizing the bunker sample location, the difference between BIMCO terms and BIMCO bunker quality clause for time charter parties? And if the ship's manifold sample tests 0.53% for very low sulfur fuel oil, what actions can the owners take? Diego, I think this is a question for you.
Thank you, Roy. Now, regarding sample location, the specification ISO 8217 states that the samples shall be taken according to the sampling method ISO 13739. This sampling method states that the samples shall be taken from either end of the bunker hose, although it recommends taking the samples at the ship's manifold. Unfortunately, this is a recommendation, not a requirement. I personally believe that this is a big mistake, which is creating lots of problems to all parties involved in the bunker dispute. If you think about it, logically, the samples should be taken at the vessel's manifold and not at the barge manifold. This is because the bunkering hose belongs to the barge. So the actual barge vessel connection point is the vessel manifold and not the barge manifold. In addition, think about what happens if the bunker hose, for example, is dirty with some contaminants or has residues of a previous high sulfur fuel. By taking the samples at the barge manifold, you cannot find them as the barge manifold is placed before the bunkering hose. So barge manifold sampling makes no sense, and there's no doubt there. Now, there have been some efforts to harmonize the bunker sampling location. For example, there's a national standard in Singapore where I'm based, that specifies that all samples must be taken from the vessel's manifold for all bunker supplies within Singapore. But outside Singapore, it is still a matter of your charter party clauses when it comes to a commercial dispute. It is up to the charter party clauses, and the fuel specifications, unfortunately, up to date, are not conclusive yet. Although more and more clauses and international bodies are stating that the sampling location should be the vessel manifold. For example, the BIMCO bunker quality clause for time charter parties is very clear in stating that the representative samples should be taken from the vessel's manifold, and that only the samples are to be considered representative should a dispute arise. So what I can say is that we do not know when the sampling location will be standardized through the industry and through the world, but we expect that to happen, and we have no doubt that it will be the vessel's manifold and not the bunker manifold. Regarding your second question on sulfur, now what the owners should do. So we know that the supplier's result, which is shown in the BDN, must be equal to or below 0.50%. The ship owner's result instead will be considered compliant when the allowance of 0.59 R is applied. This means that the fuel is considered within specification if the ship owner's test result is within 0.53%. This allows for any potential testing uncertainty between the suppliers and the ship owners' laboratories. When this scenario arises, no actions are required to be taken by the ship owners. So to translate it, when your routine fuel testing program finds the fuel to be 0.51 0.52 or 0.53 sulfur content, you should do nothing and use the fuel. Or more accurately, there is nothing much you can do, since you have no claim. You have no claim against the supplier. The only thing you may consider to do is taking, sealing and retaining a sample from, for example, the settling tank while you use the fuel. Also, you may consult your flag. The problems when your fuel tests 0.51 or 0.52 or 0.53 comes with the port authorities. The authorities can rely on 3 types of samples for their investigation. They are the marble delivered sample, the onboard sample, and the in-use sample. So the first one is taken at the vessel manifold during the supply, and the other 2, so the onboard sample and the in-use samples, are taken from either the storage tank or the transfer pump or the settling tank. If the port authority chooses to test the marble delivered sample and the sulfur result is found to be above 0.50%, they may consider the fuel to be non-compliant. If instead the port authority chooses to test the onboard or in-use samples, then they should consider the testing uncertainty, and therefore results up to 0.53% are to be considered within the limit. Yeah, back to you, Roy.
Thank you. Thank you, Diego. Well, we have a question for Amy. So the question is, there was an engine damage case. The cause of damage was repairer's negligence during last overhaul. How do we know if the damage was purely caused by the negligence of the repairers?
Here I'm off mute. So repairer's negligence is covered under IGC if those were the conditions, and so we'd be looking at what the proximate cause of the damage was. That's what we're required to look at under the Marine Insurance Act. And so the proximate cause is the one that's proximate in efficiency, so the predominant cause of the loss, which isn't necessarily the one in time. So if the cause of damage was repairer's negligence in the last overhaul, we would be discussing with the surveyors, H&M surveyor, consulting surveyors, to find out whether that's the case, if there's any other possible intervening cause. If not, then that would their expert advice would be what decided whether it was the damage was purely due to negligence of the repairers or if there was something else. And also we would be looking at things such as whether it was a progressive damage, if it occurred over several policies, if it or if it was just kind of, damage that occurred under one policy. If it occurred over several policies and it was progressive in nature, then the surveyors would give us a split of the percent of damage per policy, and we would apply that to the policies as well. But I think that we're mainly guided on cause of damage by the experts involved and on the technical basis for the damage and likely causes, if that answers the question.
Thank you. I think that's it. I think that concludes our session today. I hope you found it informative. If you think of any more questions, feel free to reach out to any of us directly. And again, please fill out the survey, as your feedback is important to us. Goodbye for now. Thank you very much.